Court of Florida is now in session. Please be seated.
Okay, the next case on the docket is Brown versus State. Whenever you're ready, counsel.
Thank you, Your Honor. May it please the court? I'm Chris Anderson, counsel for appellant Thomas Brown.
Speak up, please, in your mic.
Is that better?
Yes.
I'm Chris Anderson for appellant Thomas Brown, and I would like to clarify at the beginning that the issue on appeal, the one sole issue on appeal, is whether the defendant suffered prejudicial ineffective assistance of trial counsel when his trial counsel failed to object to a prosecutor's statement that indicated falsely that the defendant had premeditated the murder. The only issue in this murder of a Wendy's fast food restaurant worker was whether defendant Thomas Brown committed unpremeditated second-degree murder, which he admitted to in trial, or whether he committed premeditated first-degree murder. And I'm going to recite the full problematic statement of the prosecutor.
Can I ask you, did you have an evidentiary hearing on this issue?
Yes, we did, Your Honor.
And did the defense counsel explain why he didn't object?
Yes, Your Honor.
So the trial court then found that it was a reasonable strategic decision. And I guess I'd like to, even if there was something that was not quite according to the evidence, the trial lawyer says why, you still have to establish prejudice.
Yes, Your Honor.
Which was both were they both evaluated by the trial judge?
Yes, Your Honor.
Do we have any case out there where in a ineffective assistance of a guilt phase that a possible strategic decision in closing argument to a particular statement in itself would undermine confidence in the entire guilt phase of the trial?
The closest I can come to that is Nixon versus Singletary, in
Who?
which
I'm sorry, who?
Nixon versus Singletary, in which the court held that an admission to guilt is per se ineffectiveness without the need for any further proof. And the problem in this case is, and let me recite.
Nixon.
Yes.
Got reversed, didn't it?
The U.S. Supreme Court reversed that one, didn't they?
There's several Nixon versus
Okay.
Singletaries. Okay.
Well, the Nixon one, where the young man here in Tallahassee,
I don't know what part of town he was from, Your Honor, what part of the state.
and if he got a car over at the Governor Square Mall, and tied up the victim with the battery cables, and he refused to come to trial, would take his clothes off, and those kinds of things. And this court said that's ineffective assistance. U.S. Supreme Court said no. That sometimes that's the best defense to take, and reversed, didn't they?
Well, I cited for the proposition that admitting guilt is per se ineffectiveness, and I believe that
But that's what the Supreme Court said is not.
I can't really comment on
Okay.
why the
All
Supreme
right.
Court's
All right.
rationale is.
I'm sorry, go ahead.
But even without regard to what the U.S. Supreme Court did later on, if the only issue in a case is whether it's a second-degree murder, which you admit to, or it's first-degree premeditated murder, which you deny, and then you sit still while the state argues to the jury and misquotes the defendant as admitting to second-degree murder, admitting to first-degree murder.
Well, but let me ask you this. Isn't there evidence in the record that the defendant stood over the victim and angrily said, "I told you I would kill you"? And he went on to elaborate and to characterize her in a particularly despicable way. But didn't he say that? And then he fired his final shot?
Yes, Your Honor, and let me tell you, he did say that, but he didn't say the rest of it. What he said was, and this
He
much...
said it 4 times?
Not 4 times, no. What the defendant said was, "I told you I'd kill you," when he stood over the victim and fired the last shot, okay? But what the prosecutor said was, the prosecutor misquoted the defendant as saying, "I told you I'd kill you. I had it in my mind to kill you. I've wanted to kill you for several days. I've wanted to kill someone to take out my frustration."
Let me ask you this.
That's a quote.
The defendant was at the Wendy's, correct?
Correct.
Whether he was fired or not fired, he left the premises, right?
Actually started to leave twice, yes, Your Honor.
Okay, and so at the time he was on the premises, there's no evidence that he had any kind of weapon on him, correct? At the initial time he was on the premises, when he was arguing with the franchisee guy, there's no indication he had any kind of weapon on him,
That's
correct?
correct.
He leaves,
Yes, Your Honor.
and when he comes back, he has a weapon on him.
Yes, and for clarification,
Wait a minute, is that not correct?
there's no evidence whether the first time he was in there he had a gun in his pocket or not, but we know when he came back.
We know when he
shot-
came back.
He had
He
a gun.
came back in with a weapon,
Correct.
okay? And did he ask for Mike first? Or he just saw the victim and pulled the gun? Isn't that what happened?
I hope I'm answering your question correctly, but what happened was, at the meeting, it was Mike and Mommy, the franchisee of the Wendy's restaurant, the defendant was speaking to, when he said, "You don't know me, there ain't going to be a Wendy's." Okay, that's what he told Mike and Mommy, the franchisee, not the victim. He asked Mike and Mommy why his hours had been cut, not anybody else. Another employee testified hearing hearing the defendant say to Mike and Mommy, the franchisee, "Someone's going to kick your A." It was also Mike and Mommy that admitted that he had, at that meeting, later on Mike and Mommy testified that he had changed the defendant's position. So,
So
now-
at this
now going
point,
to-
he's angry, he goes to his car and comes back.
Yes. On the day
And
of the-
start shooting.
On the day of the murder, when he first entered the restaurant, he asked for Mike and Mommy. When he first entered, the actual victim, the Wendy's fast food worker, was standing in line ordering food. He showed no interest in her, he had no issue with her. So he comes in, he asks for Mike and Mommy, and he finds out Mike and Mommy is not there.
But then he sees someone else who he feels is a part of why his hours are being cut, why he's being treated the way he's being treated, and he opened fires.
No. He went to his car, started to drive off because Mike and Mommy was not there, started to back out, then he re-entered the store, and he said, "Where the F is Mike and Mommy?" And when he found out Mike and Mommy was not there, he started to walk out the door. He didn't go into the parking lot. He turned around, went back into the restaurant, and then he started shooting.
Let me ask you this
Yes,
question.
Ms. Miller.
And how many times was the victim in this case shot?
At least 3 times.
3 times.
Yes, Your Honor.
And when the final shot was fired, I take it that the victim was still alive?
I believe, I don't know. I know he shot her 3 times. I don't know which was the fatal
Okay,
bullet.
so what was it that your client actually said to the victim at that point? What was it that you say in the prosecutor? You read to us what the prosecutor said. What was your position as to what was actually said by your client?
Okay, the last thing,
I told you I'd kill you. Is that it? Is that, I told you I'd kill you. Did he say that?
no, what he said, now you can, the last thing he said to the victim was, "Now you can go and tell Mike thanks." And he also did tell the victim, "I told you I'd kill you."
Okay, so
He did
let me
say
ask you,
those two things.
so you have a factual situation you just described where he came back into the store with a weapon, asking for these people. He shoots the victim point blank, and you tell me the jury was prejudiced because of what the prosecutor said into believing that it was premeditated?
Yes, Your Honor, and here's why.
Well, what does it take for premeditation to occur? You shoot him 3 times.
Okay? That proves he had a motive. That proves he committed a homicide. For first-degree murder, you need premeditation. And what is premeditation under the rules, under the jury instructions? It requires a conscious mind, a decision to kill. It requires time for reflection. What we see in this case,
He fired the gun 3 times, at least, right? He shot 3 times.
impulsively.
How is not reflection?
Impulsively, not premeditated.
I thought the evidence, you had said 3 times. I thought the evidence was he shot her 4 times and then stood over her and said, "I told you I was going to kill you," with some expletives, and then shot her in the head. Is that factually?
He shot her multiple times when he first went to shoot her, then he started to leave the restaurant, came back in, and when she was laying on the ground, shot her yet another time.
Okay.
Yes, sir.
What was the defense in this case?
I'm sorry, what was
What
the...
was the defense? What was the strategy?
The defense was to admit second-degree murder, and they did. They said this is second-degree murder, it's not premeditated. Okay. Here's the problem. There's evidence of it being both a spontaneous, impulsive shooting of the worker instead of the manager, and there is evidence of premeditation. There's both. And so it was up to the trial lawyer to explain, having admitted it's second-degree murder, not premeditated, to explain to the jury why it was not premeditated.
But you're not saying that the trial, in this sole claim on appeal,
Yes.
you're not saying the trial lawyer didn't put on, or should have put on more witnesses to explain the facts differently.
No, in fact, we
You're
admitted...
saying that the prosecutor misstated a quote?
Yes, Your
Okay,
Honor.
and did we, in our direct appeal, when we quoted what Brown said, did we misquote any of the quotes?
No,
Are
I
they,
don't-
are our direct appeal quotes correct?
As I recall, you, and I could be wrong, but I don't think you quoted the full prosecutorial statement in
Well,
the direct
I
appeal.
told you I would kill you, you effing bitch. Was that an inaccurate quote?
No, there was one witness that said he said that to her when she was down on the ground with the final shot. What's an inaccurate quote is, correct, the prosecutor's correct when he quoted the defendant saying, "I told you I'd kill you." He did do that. But then the prosecutor added, "I had it in my mind to kill you. I've wanted to kill you for several days. I wanted to kill someone to take out my
Okay,
frustration."
now here we're talking about whether CCP, which is a penalty phase issue, was CCP found by the trial judge?
Yes, and
Okay, so now on retrial in the penalty phase, you can maybe argue, and it will be important to argue, that this was, although it was first-degree murder, it was not being contemplated for several days because this is what your client said. And it seems to me that would be the appropriate place to talk about whether there's any prejudice for the finding of premeditation, which is Justice Labarga is saying, can occur, there's a shot, there's a shot, there's a shot. You don't need anything more for premeditated murder, do you?
Yes, you do, because, and I thought of an analogy for this, Your Honor. I thought of this. According to the jury instructions, premeditation requires a conscious decision, a reflection, not an impulsive act. And if we don't accept that much as true, there's no difference between first-degree murder and second-degree murder.
But again, saying that one quote, and I'm not going to repeat it, we have cases where there's just shots and we say there's premeditation. He says something, and what the something is that I told you I would do this, and I'm doing it.
Yes, that is evidence of premeditation, but there's also evidence that...
Let me ask you this.
Yes.
Why am I wrong in thinking that the impact on the jury would be no different if the prosecutor directly quoted what we have in the record about what the defendant said as he was shooting the victim in the head, and what he had written in his little diary, where he talks about, I just offed the victim, I'll say, because she was the cause of my life being, of his problems. I'll clean it up. If she ain't dead, then she can learn how serious words can be. When you put all that together, I have a hard time of seeing why the impact of reading all of that to the jury would be any different than what the prosecutor actually said. And so why am I wrong in thinking that if the jury had heard that, they're going to be thinking the same thing that they're thinking when they hear what the prosecutor actually said?
I'm glad you asked me that, Justice Kennedy.
I'm glad I asked it.
And here's why. Okay. The way it would work in closing argument is this. Ladies and gentlemen of the jury, there's only one question for you to answer. My client has already admitted he committed second-degree murder. We deny that this was a premeditated murder.
Well, I think he might have admitted he committed premeditated murder.
Well,
By what's quoted here.
the evidence, first of all, we know we're dealing with a different individual. He ended up killing somebody that put ice down his back. But when he entered the restaurant on the day of the murder, he went there for Mikey Mommy. And the decision to go back and shoot Juanese Miller, the Wendy's worker, was a spontaneous, spur-of-the-moment, unpremeditated action. It's a lot like when you go to a supermarket and you have your shopping list and you think it out, you premeditate. Now, if you're walking out of the check stand and you have no intention, you never thought about this, but you grab a chocolate bar and you throw it in the conveyor belt, that's not a premeditated decision.
Well, how long does it take to form premeditation?
Well, the case law says there's no time, but it has to.
Exactly, that it can be formed in a few seconds, can't it?
That's what the case law says.
If you make your decision about what you're going to do, and it does not take a long time to do so. And you've had time for reflection.
Yes.
He certainly had time for reflection after he shot her the first couple of times. Then he stood over her and said what has been quoted here and shot her again. So you're saying to me that that is not enough time and reflection to form first-degree murder?
What I'm saying is that there is evidence that it was first-degree murder, and there's also evidence that it was unpremeditated second-degree murder. There's
So
both.
who makes the decision?
The jury.
The jury makes the decision about whether or not it is first-degree murder or second-degree murder.
Yes.
Okay.
You're down to your rebuttal time, but before you sit down, one quick question.
Yes, sir.
What was the firearm used? Was it a semi-automatic and was it a revolver?
I just know it was a pistol.
Okay, well, pistol, it's not a revolver. I'm just wondering, because, thank you.
Thank you, Your Honor.
May it please the court, Christina Pacheco with the Office of the Attorney General for the state of Florida in this case.
Let me ask you this. Where in the record, what in the record supports the prosecutor's, that portion of the prosecutor's statement that says, I wanted to kill you for several days. I wanted to kill someone to take out, well, to take out my frustration part, but the part that he says, I wanted to kill you for several days, where is that supported in the record?
It's supported in many different areas. If we look at the circumstances of the murder, Your Honor, you are correct in that when Mr. Brown returned to Wendy's, he came with a firearm. He first asked for the franchisee owner. At that time, Miss Miller was ordering her food. He sees her, he leaves, he gets in his car, he comes back. At the door, his girlfriend at the time tried to prevent him from entering, and he says, she's the reason why I don't have my job. He walks in, and before she even has a chance...
Who made that statement in the record? The former girlfriend?
Yes, her name was Angelette Harley, and she said that the second time that he came in, he told her, she's the reason I don't have my job, referring to the victim. He walks in and within a very close range pulls out his gun from his waistband, fires 3 times, leaves, turns around, and says, "I told you I would kill you, you fucking bitch," and fires the fourth and final shot. So, and then after, he writes in his journal, "I just offed a bitch because she was the cause of my life being effed up." So when we look at all of those circumstances, you know, and what the prosecutor said, the first statement, "I told you I would kill you," clearly that was a direct quote from him. In fact, the quote that he actually said was worse than what the prosecutor, she cleaned it up a little bit. The rest of the statement, which Your Honor is referring to, that can be seen from the fact that, well, he told her that he would kill her, so apparently at some point before he fired the fourth shot, he had told her at another time that he would kill her. All of the evidence from the trial showed that on that morning, both the defendant and the victim worked together. There were there was no argument or anything in between them.
No new altercation between them that day?
No, nothing that day, so it had to have occurred on a previous time before that. And so he told her he would kill her at some point, and then he did again when he shot her.
So the prosecutor was paraphrasing what had been said in different instances.
Exactly. It was a paraphrase of the evidence that was introduced during trial, much of which were the defendant's own words. It was
and
just
really, the lawyer was given a chance. They put him on the stand. Did they put him on the stand, or did you?
We put him on the stand, Your Honor.
And he said he was about ready to get up to object, and then he realized that he was just paraphrasing. Is
Yes.
that what he said?
He said that it was clear to him and everyone in the courtroom that the prosecutor was not intending to quote directly from Brown. It was just a
And it could
paraphrasing.
have really led, if he said, he's misquoting it, all my client said was, I mean, it still amounts to whether he thought about it that day or it's 2 days. We're not here on this issue of CCP. We're here on the issue of whether the jury would have still found premeditated murder. Correct?
Exactly. And I believe Justice Kennedy said it best, that there really would have been no difference had the prosecutor quoted directly from Brown. It was a paraphrase of his statement, and there's really, not only has there been a showing of deficient performance, but really no prejudice whatsoever here, given the evidence that was adduced at trial, the overwhelming evidence of premeditation. And Mr. Anderson's arguments regarding premeditation are not really related to, he's not showing how that impacted whether the trial counsel should have objected and how that impacted premeditation. This court already found that there was sufficient evidence of premeditation. So how he can say then that failure to object to that very specific argument during closing argument somehow impacted the jury's finding of premeditation, no matter which way you look at it, there's just no coming to that conclusion based on these facts. Other than that, if this court has no questions, I would just rely on the rest of the arguments contained in my briefing and respectfully request that this court affirm the lower court's findings. Thank you.
Counsel, you have a few minutes for rebuttal, 2 minutes and 10 seconds, as a matter of fact.
Let's not mistake sufficiency of evidence for effectiveness of counsel. We have already, I've stated clearly and candidly to this court, there was evidence of premeditation. There was also evidence that the murder was spontaneous and unpremeditated.
Well, how do we deal with, we know from Strickland and all the other cases about ineffective assistance of counsel that we don't look at these cases with 20/20 hindsight. And yeah, maybe an objection could be made. And then what would the objection have done? Would the trial court say, what? What would the trial judge have done if there had been an objection made?
Either declare a mistrial, but more probably a curative instruction, Your Honor.
A curative instruction that said, oh, he said, I told her I would kill you, whatever the rest of it is. And he also said that because my life was so messed up and you're the cause of it and all that. So that's what he said, but he didn't say, I was thinking about it for several days. That's what the curative instruction would be?
Yes, and the way it would play out in the jury room is this way, Your Honor. The jury would go, even though this is not about diminished capacity, but they'd look at the whole scenario and think this is not a normal human being that ends up shooting somebody that puts ice down his back. But you know what? Clearly he was mad at Mike Imami. He came back to the restaurant to shoot Mike Imami. And he even went back to get in his car, and then that would have been premeditated murder. No question, if he'd shot Mike Imami, his intended target, it would have been premeditated first-degree murder. But he didn't. Something inside of him...
He wasn't there. Something inside of him says, well, let me go back. I saw her in there. And so his girlfriend says, you don't want to come in here. She's the cause of all my problems, and that's not enough for premeditation.
It is enough for premeditation, and it's also, and there's also enough for second-degree second-degree murder, and that's the problem.
Which is subsumed in the first degree.
Yeah, in other words, once the rest of that quote came in that was not an accurate quote, I had it in my mind to kill you, I wanted to kill you for several days, I wanted to kill someone to take out my frustration, and then defense counsel sat silent, the jurors probably accepted the state's statement as a true statement, and said, well, gee, he admitted to premeditation, what are we here for?
Okay, we're out of time. Thank you for your arguments. The next case on the docket is Shepard.